Okay, and you also said that Ms. Duggan was responsible for the appointment, and I've seen paperwork that you've given me to that effect. Can you remind me again whether she's a member of the board or what her position is exactly?
She was a manager there. Don't recall exactly what position she was, but she was a manager of, I think, compliance, but she was not a delegated authority from the legal board to make that delegation decision. And also she made the second delegation decision for Ms. Hubble-Marriott, partner at Russell Kennedy, to come in around about August, September 2022, a year later.
Okay.
To do a second audit.
So we've had a look at the legislation, and Section 44 of the Legal Profession Uniform Law Application Act, which sets out the board's power of delegations, clarifies that the board cannot delegate its authority to further delegate the authority. So all delegates of the board cannot themselves appoint delegates to carry out external intervention or audit. So that appointment was invalid.
Mm-hmm.
And we've also gone through the annual report of the Victorian Legal Services Board and Commissioner's Office from 2022. And it notes that the delegation of Ms. Duggan was revoked because it says that her job title had changed from the manager of regulatory compliance to the manager of investigations. But then, very strangely, the regulatory provision that it cites for the authority for the revocation sets out the basis for the exercise of that authority, and it makes it explicitly clear that it only applies in circumstances where the person who had been appointed as delegate originally is found to lack the character or the competence that a delegate must have.
Yeah.
And it's not simply a provision that can be invoked without necessary implications and necessary inferences about the character and suitability of that person to carry out their job. And more importantly for you, it essentially invalidates the appointment.
Yes.
And, well, in your case, Mr. Neylon's appointment was not valid to begin with, but if there was any doubt in that respect, then because the authority pursuant to which Ms. Duggan had extended the delegation had been revoked, that delegation of Mr. Neylon, or that appointment of Mr. Neylon as a delegate, would have also been revoked even if it was right.
Yes.
So did the board inform you about this matter?
No, not at all. Not to date. Not to today's date. Nothing has I've received any information about that.
And I'm aware that they're continuing to persecute you through VCAT. Have they revised their statements about the history of your dealings with them? In that, have they corrected the situation about the Neylon appointment?
Not at all.
So they continue to maintain that the Neylon appointment and all the consequences that stemmed from it were legitimately achieved, and that you should continue to suffer the adverse consequences of that appointment.
That's correct, which culminated in a letter dated the 11th of October 2023, saying that I hadn't complied with Damian Allen's management systems directives, which was to provide details itemised details of every file out of 300 odd clients we had, every month for 12 months, which we complied with, based on what they told me they wanted to have as a tabulation. So I had to employ a staff member solely every month, basically for days, to look at every file and everything that happened in every file for the Legal Services Commissioner to look at. So it was really an onerous compliance, and I've never heard of another legal practice having to go to that extent of compliance.
And what was the basis for the issuance of those management system directions?
They believed that I was not on top of the files and I wasn't managing my staff correctly, which I'd done for many years prior. This was 2021, end of 2021. So that started for 12 months, which led afterwards to Hubble-Smith coming in to follow up with a second audit. And also I'd like to add that when Damian Neylon was there, he cornered my staff about this other court matter and how I was being successful there, spoke to me in person, that he'd already spoken to that senior associate when prior to coming in for his interview with me and my staff, and she had made allegations that I was interested in her, which was news to me. She'd already had a boyfriend and we had socialised. She'd been there for 5 years. I had no interest in her because at that point in time I was still in a relationship and had a young son, and she knew all that. She'd even been to his baptism. But he also said that I shouldn't have Chinese and Indian clients because they don't pay, and I shouldn't take on mask cases because my website at the time, we were having a lot of success against the Victorian government for mask cases and people were being fined and overturning those fines. And he said the government didn't like that. So he was putting me on notice that I was under the watchful eye of the Victorian government, and also that I'd been a Liberal candidate in 2002 for the Liberal Party. So I was under special watch because of that. And I took that as a threat. And I answered, and in my response to Neylon's point that I have Asperger's, I also responded to that in my response after his report, saying I shouldn't be singled out and ostracised and treated differently because of my Asperger's.
So you're saying that you weren't losing in court and your clients were not complaining about you?
No.
So they didn't really have any reasonable basis to conclude that you weren't doing your job properly?
No. But I'd like to add also that in January 2019, when I was undertaking cancer treatment, they decided then to send an auditor in, a trust auditor from the Law Institute. Now this was a follow-up for many years from the success in 2014 of my Supreme Court of Appeal, Victoria, where I received just under $100,000 in costs against the Legal Services Commissioner. And at that point, and there was no complaint, it was a family matter of the late mum's estate. My brothers didn't complain, they got their inheritance, there was no complaint. They initiated their own complaint, the Victorian Legal Services Commissioner, which went on for 5.5 years until I was charged at the end of June 2024, which was like 8 months after they had moved in and taken my business. But why they suspended me for 2 years until October 2025 was based on apparently not having followed the management system directions of Neylon and not having let Marriott Hubble-Smith come in for after day one for further days to continue her audit. And the reason being I didn't let Marriott back in was on the Friday she cornered my junior graduate lawyer for over an hour, which led to her having serious health issues and hyperventilating and ending up in hospital that Friday night. So I wrote to Hubble Marriott and said, you cannot continue your audit. I've had to report this to WorkSafe because my staff are now under health danger. Ultimately, she still turned up at my office on Monday morning and was arguing that she had a right to continue on. I said, I've written to Mr. Anstey, Manager of Regulatory Compliance, who was part of this appointment under Alice Duggan, that he should put in processes and procedures that she can continue her audit, but I don't want my staff fearing for their safety or ending up with hyperventilating or having medical conditions.
Did she deny the allegations that were being made against her?
No, she didn't. She just said that I have the statutory right to continue. you're prohibiting me. I said, I'm not prohibiting you. I'm allowing you to come in, but there have to be procedures put in place.
So you're saying she didn't deny that she had treated your staff?
She didn't. No, she didn't deny it. She was just on the mission that she had the statutory right to bulldoze her way in, irrespective of what harm she was causing. She was already stopping the practice from functioning because she was asking for files from different lawyers. She was taking them in the office and taking up their time. And I was allowing all that. She'd even wanted to interview me, and I said, I'll only have an interview if I'm allowed to record the interview for my legal rights under the Surveillances Act Victoria. She said no. She said the interview will not take place now. I said, I want this done because I didn't do that when Neylon was here and he was putting serious allegations to me, which were not part of his audit, like the allegation that I was interested in this senior associate. So she was making up these allegations, having spoken to him prior to him coming in, because she'd set the agenda that I wasn't functioning.
So you're saying that you told the Victorian Legal Services Board appointed auditor, Ms Hubble-Smith, that you wanted to exercise your right to record the conversation of which you were
a party to.
And she said that if you record the conversation, then she would not engage with you.
That's correct, and I wasn't going to be allowed. Correct.
But what did she have to hide?
Well, that's the question. And that was raised on the Monday morning. I said, I've written an email to your manager asking for guidance on moving forward, to which I received a one-word response, noted, and nothing further was done to today. And ultimately, that led to those charges that they made up for their allegedly not providing the management system directives and prohibiting her from continuing with her audit, to say that I was not a fit and proper person on the 11th of October in their letter, 11th of October 2023, to move in, lock me out, take my life's work, sell it off, give me nothing for it, and throw me on the street.
So you're saying that Matthew Anstey had acknowledged receiving your complaint. No one denied the substance of it.
I believe it was his staff that noted that she'd received it. I also wrote an email to him, and to this day, even in their brief to VCAT, they have not made a mention of any of that correspondence. They've just blanketly said, I denied her access, even to the point where clients were coming in and she was disrupting the practice, standing and shouting around, that I had to tell her that I was going to call the police and have her removed. And she said, yeah, go do it. Then eventually she left and she said, I'll be back, but she never returned. Then she wrote her report without me having any more input, just wrote a report in her own words saying that I didn't comply, that I didn't let her back in, didn't mention what she'd done to my staff, and that's been reported to WorkSafe in writing. And it was just said that apparently I was a bad person again, the narrative.